to the December 15, 2021 Planning and Zoning Commission meeting. First item on our agenda is roll call.
Chairman Chernick.
Here.
Commissioner Flagg.
Here.
Commissioner Kohler.
Here.
Commissioner Height.
Hear me?
Okay, gotcha.
Sorry, present.
Commissioner Honoron.
Here.
Commissioner Poland.
Here.
Commissioner Teta.
Here.
Councilmember Rodriguez.
Here.
Chairman, you have a quorum.
Thank you, Jane. Appreciate that. Anyone wishing to speak during public invited to be heard, items 4 and 8, or whoops. Apparently when Dallas puts the slide up, it makes my other things on my screen go away. So hang on a sec here. Let me get back to my script. Okay. Anyone wishing to speak during public invited to be heard, items 4 and 8, or during any public hearing items, agenda item 6A, will need to watch the live stream of the meeting for instructions about how to call in to provide public comment at the appropriate times. Instructions will be given during the meeting and displayed on the screen when it is time to call in to provide comments. Comments are limited to 5 minutes per person, and each speaker will be asked to state their name and address for the record prior to proceeding with their comments. Please remember to mute the live stream when you are called upon to speak. But before we do the first public comment, we have a communications item on our agenda. Director Glenn Van Nimwegen, do we have any communications from you?
Mr. Chairman, I do not.
Okay, so Dallas, now if we could put the slide back up again for the public comment, public invited to be heard. And the information is now on your screen for those viewing from home. Please call 1-888-788-0099. When prompted, enter the meeting ID 868-6086-1062. When we're ready to hear your public comment, we will call on you to speak based on the last 3 digits of your phone number. Each speaker must state their name and address for the record and will be allowed 5 minutes to speak. Please remember to mute the live stream when you are called upon to speak. We'll take a 5-minute break to do this. We will be back at 7:08.
Chair, we are just shy of 7:08. There are currently no callers.
Alrighty, thank you, Dallas.
Yep.
We will close the public invited to be heard since nobody called in. We will move on to item 5 on our agenda, which is approval of the November 17, 2021 minutes from the commission. Do we have discussion or anybody want to make a motion to approve the minutes? Commissioner Pullen.
I move approval of the November 17th, 2021 meeting.
Okay, do we have a second for the motion to approve the minutes? Commissioner Teta.
Second.
All right, we have a motion to approve the November 17 minutes and a second from Commissioner Teta. Any discussion? Seeing none, we'll do a roll call vote in no particular order. Commissioner Teta,
Aye.
Commissioner Poland,
Aye.
Commissioner Kohler. I'm sorry?
Abstain.
Okay,
I wasn't here.
got it. Okay. Commissioner Height,
Likewise, have to abstain.
right? Commissioner Oneron.
Abstain. I wasn't there either.
Okay. Commissioner Flagg.
Aye.
And I was there and I will say yes. And so Jane, that passes 4 yeses, 0 no's, and 3 abstentions. So the minutes are passed. And next on our agenda is item 6A, which is a public hearing item. It's an appeal of an administrative decision to deny a short-term rental permit for 226 Emory Street, PZR 2021-13. Principal Planner Don Burchett will do the first presentation.
Good evening, Chairman Chernak, members of the Planning and Zoning Commission. My name is Don Burchett. I'm the Planning Manager for the City of Longmont. And with me tonight, we have Dane Hermson, Senior Code Enforcement and Substandard Housing Inspector. Dallas, if you'd start the presentation, please. The item before you tonight is an appeal of an administrative decision to deny a short-term rental permit for the property located at 226 Emory Street. Next slide. The applicant, Ms. Teddy, was denied a permit by Mr. Hermson after he found that the application did not comply with the Land Development Code section 15.02.080D2B. Mr. Hermson determined that based on the information submitted by the applicant for the permit, that the owner was not a resident of Longmont, but is a resident of unincorporated Boulder County. Next slide, please. The Land Development Code section 15.02040K8 allows the property owner to appeal this decision to the Planning and Zoning Commission for a hearing where the commission shall review the case and either uphold, modify, or reverse the administrative official's final decision. Next slide. In order to complete the appeal hearing, the commission should use the following outline for conducting the hearing. This information can also be found within your Planning and Zoning Commission packet on page 4 for future reference. The process briefly is first, there will be a staff presentation of the report, which is what I am doing right now. I'm about 2 minutes into that presentation, followed by a presentation by Mr. Hermson and myself of the application and the process that we went through. That is limited to no more than 30 minutes. The appellant then will be allowed a presentation, again, limited to 30 minutes. There is an optional public hearing. This is not required, but typically is done in the city when we have appeals to augment the record or to consider additional evidence. The hearing itself should be limited to 1 hour. We recommend a 2-minute limit per speaker, but that's just a recommendation. If you do open the public hearing, You are asked to provide the opportunity for staff and the administrative official and the appellants to rebut anything that is offered during the public hearing. The rebuttal for each staff and the appellant should be limited to 15 minutes each, and that's in addition to the maximum hour for the public hearing. After that, the Planning Commission can do discussion and questions of the applicant and staff. And then after you have had the opportunity to ask those questions, there should be an opportunity for rebuttal by staff, the administrative official, and the appellant of the original presentations. Again, each of those should be limited to no more than 15 minutes each. And then finally, after the rebuttal, the Planning Commission can do another discussion. If you ask staff questions or the appellant, then you will need to offer another opportunity for rebuttal if you ask any additional questions during that discussion of either party. The Planning Commission then needs to make findings and consideration of a motion. There are planning and zoning resolutions in the packet that give you three options to look at, again, to uphold, to modify, or overturn the decision. I will now give a brief overview of the application, which will be followed by Mr. Hermanson explaining how he came to his final decision. Next slide, please. According to the Land Development Code, short-term rentals are allowed in all residential districts, all mixed-use districts, and in the ag zoning district, subject to conformance with use-specific standards in section 1504-030 D23, which refers you to section 15.02080D, which is included as attachment 2 in your communication. Next slide. According to D2 of the code section for short-term rentals, they're only allowed in two instances. The first is when it occurs in the owner's primary dwelling, and the second is when it occurs in an investment dwelling of a resident of Longmont. As Mr. Hermanson will explain in his testimony, that the applicant submitted information that showed that the dwelling is not the owner's primary dwelling, and that it was a second or an investment dwelling, and the owner is not a resident of Longmont. Staff determined that a resident of Longmont is someone who lives in the corporate limits of the city of Longmont, and the evidence attached to the communication clearly shows the owner is a resident of unincorporated Boulder County. I'll now ask Mr. Hermanson to provide the commission with a brief overview of the application process and the steps he took in making his decision to deny the application.
Thank you. Chairman, Commissioners, we received the application on September 23rd of this year for review. And during my review, I found that the owner's home address was 9747 North 89th Street, 80503. This is an enclave of unincorporated property within the larger Longmont area. I checked with planning and with my boss as well to see kind of what they thought of the situation, and we all determined that we really needed to consider a resident to be someone that lived within the incorporated city limits. At that point, I notified the applicant and issued the letter of denial.
Thank you, Dane. Next slide, please. In conclusion, the administrative official denied the short-term rental permit after determining that the applicant failed to meet the standards in section 15.02080 D2b, and specifically the property is a second or investment dwelling, and the applicant is not a resident of Longmont. The appellant's own letter, attachment 5, states in the first paragraph that she resides at 9747 North 89th Street, Longmont, Colorado, which means she resides in unincorporated Boulder County and is not a resident of Longmont. As such, the applicant failed to meet the requirement and the permit was denied. This concludes our staff presentation. Thank you.
Thank you, Don. Okay, so let's move on to the appellant's presentation.
Good evening, everyone. Can you hear and see us all? Okay, thank you. Members of the Planning and Zoning Commission, my name is Ben Wilson, and I'm an attorney in Boulder County. With me tonight is my client, Jenna Tatey, the homeowner whose STR application has been denied. The facts of the matter are essentially undisputed. Ms. Tatey lives just outside of the city limits of Longmont, and that her application for an STR license was denied because she does not live within the city limits. First and foremost, the STR ordinance in the Longmont Municipal Code, or LMC 15.02.080, subsection D, does not actually require that a property owner be a resident of the city of Longmont in order to obtain an STR license. The ordinance uses various language and inconsistently. For the most part, the ordinance simply refers, as the presentation from staff showed, to residents of Longmont, and those are the parties to whom an STR license is restricted. Going through that ordinance just a little bit, and staff would like to refer to it. It's Ordinance O-2021-36, I believe is the most current version. It's updated this last July. Go through a couple of points in that, please. First, subsection D1 of the STR ordinance says that a second or investment dwelling, such as would entitle one to an STR, at least consideration for one, means a Longmont property owner's second or investment dwelling where the owner does not live for the majority of a calendar year. Importantly, this does not say a city of Longmont property owner. The second point in the ordinance is subsection D2 small b, also cited by staff, refers to the dwellings allowed as short-term rentals include entire dwelling units that constitutes a second or investment dwelling of a resident of Longmont. Again, it does not say a city of Longmont property owner or indicate in any way that the property owner must reside within the incorporated city limits. The third point is subsection D4 small a. In order to obtain an STR license, the STR property must be within the city of Longmont. It's undisputed that this property at 226 Emery Street is within the city limits of the city of Longmont. And the fourth point, which is subsection D4 small a small Roman 4, refers to the proof of residency that's required of city of Longmont residents who own an STR license, but it doesn't say anything about what forms of identification or proofs of residency might be required to someone who lives in Longmont but not within the incorporated city limits. Because it's undisputed that the Emery House is located in the city of Longmont, the only question is whether the owner, Ms. Tatey, is a resident of Longmont within the meaning of the STR ordinance. Now, the code does not provide a definition of this phrase, resident of Longmont, doesn't even define the term resident. And as evidenced by this dispute, the city is attempting to impose a meaning of resident of Longmont, which is not located in the code. The code does provide some guidance as to how to interpret phrases which are undefined in the code. Code section 1.04.020, meaning of terms not specifically defined, states that in all cases where the definition or meaning of a word used in any section is not sufficiently apparent in its connection with the subject, the definition given in Merriam-Webster's Collegiate Dictionary, 11th edition, 2003, shall be taken as the true meaning. So I had the privilege of buying a copy of this dictionary a few weeks ago before the previously scheduled hearing. The only relevant definition of the word resident in that dictionary is one who resides in a place. Admittedly, not particularly helpful. The issue is circular, and the question is not answered by the code or the dictionary which the code references. So after her STR application was denied, Ms. Tatey inquired of various city officials what the working definition of a resident of Longmont was. And Ms. Tatey received responses regarding residency requirements to run for city council and serve on various city boards and commissions, which do both clearly require residency within the city of Longmont. But they did not address the question here. This all occurred in the first week of October 2021, which was after Ms. Tatey's STR application had already been denied. This raises concerns that denial was actually based on provisions of the city charter related to eligibility for public office rather than on the STR ordinance itself. In our view, the STR ordinance is not ambiguous. To be eligible for an STR license, the property owner need only be a resident of Longmont, as the term is commonly understood, including residents of unincorporated areas of Boulder County, possibly other counties near the city of Longmont. Ms. Tady's residence qualifies her as a resident of Longmont. If you're detecting that this ordinance might be somewhat ambiguous, if the STR ordinance is ambiguous, the rule of lenity requires that a law imposing restrictions on property be strictly construed against the government. Colorado court cases dating back to at least 1882 have uniformly recognized that principle. In 1882, the Colorado Supreme Court stated, quote, "In case of doubt or ambiguity, the construction must be in favor of the public," end quote. And this principle of law was reaffirmed as recently as 2017 by the Colorado Supreme Court in the City and County of Denver v. Expedia case. So in other words, where an ordinance like the STR ordinance is not completely clear, it must be construed in favor of the citizen. Here, that would mean that the STR ordinance must be construed in favor of Ms. Tady, and that the city must therefore issue an STR license for the Emery House to her. Moving on, even if the law did not require that the city issue Ms. Tady an STR license for the Emery House, which it does, there are several compelling public policy reasons why the city should issue her an STR license. First, and in a similar vein to what we discussed earlier, it's well settled law in the state of Colorado that unless it is clearly prohibited for a valid reason, property owners should be able to make free and unrestricted use of her property. Colorado courts have recognized this principle in cases such as the Edelweiss condominium case, 218 P3D 310, and that is the Colorado Supreme Court in 2009, and at least as recently as Houston v. Wilson Mesa Ranch Homeowners, 360 P3D 255, division of the Colorado Court of Appeals in 2015. Second, the City Council has held several meetings discussing the STR ordinance. The purpose of the limitation on STRs to Longmont residents was to bar absentee landlords with no connection to Longmont or ability to quickly address possible problems from creating nuisance properties in traditionally residential neighborhoods. While Ms. Tady understands the city's desire to prevent outside entities with no connection to the community from obtaining an STR license, Ms. Tady is not the sort of absentee owner the council was concerned about. She's not a corporation or a conglomerate of investors. She's an individual woman, a natural person who owns a home and a business in Longmont. She's an active member of the Longmont community. She buys her groceries in Longmont, shops and eats on Main Street, and walks her dog alongside her neighbors in Willow Farm Park, which is a tenth of a mile from her home and, ironically, within the city limits. In short, Ms. Tady is invested and involved in Longmont in exactly the way that City Council hoped an owner would be when it limited STR licenses to Longmont residents. We're also mindful of the City Council's stated concern that should a problem arise with an STR host that does not reside in Longmont would not be able to manage guests or address issues in a timely manner. In contrast, Ms. Tady lives under 3 miles, a 5-minute drive from the Emery House. She will have an ongoing presence at the Emery House when guests are there to deter any nuisance behavior and can respond quickly if the need arises. Third, there are numerous addresses within city limits that are significantly further away from the proposed STR, the Emery House, than Ms. Tady's residence is. This also highlights staff's problematic construction of the phrase resident of Longmont. In fact, if Ms. Tady lived just 30 feet to the east, she would reside within the city limits, and we would not be having this conversation here tonight. Fourth, the Emery House's location is not in a traditionally residential neighborhood that the STR ordinance was designed to protect and preserve. The surrounding neighborhood is not a traditionally residential neighborhood, nor is it anticipated to become one. The neighborhood that the Emery House is located in is zoned mixed use downtown. There is a taco restaurant directly adjacent to the property's backyard, budget rent-a-car right next to that, and an acupuncturist and a tax agent right around the corner. A large commercial space is currently being developed at the end of Emery Street as part of the downtown Longmont revitalization project. The Emery House faces the police station, a radiator repair shop, an Asian restaurant, and a large brewery. The neighborhood is already mostly commercial. An STR there would not further commercialize this neighborhood, but would instead provide an option for accommodations in an already commercialized district that is walkable to the many attractions of the Main Street and South Main Station districts. It also bears noting that the ongoing commercialization of the neighborhood makes it less appealing to homeowners or long-term renters, as evidenced by the vacancy of a similar property just 2 doors north from the Emery House. Fifth, if the city issues Ms. Tatey an STR license, the city will receive lodging tax on her income from the Emery House. However, if it does not, the property will eventually become a long-term rental, and the city will receive no tax revenue from it. As one final note, the members of the commission may recall that this hearing was initially set to take place last month on November 17th. That day, however, Ms. Tatey was notified that because there had been an error in the standard of review asserted in the communication that had been issued before the hearing would need to be rescheduled for today, and a new communication was issued. That standard of review was not, however, the only difference between the two communications. The communication that was issued in advance of the November 17th hearing stated in part as follows. Quote, "The following is a summary of the appeal issues identified by staff in reviewing the appellant's letters. Code enforcement interpreted the definition of resident of Longmont too narrowly in denying the application. It was not the City Council's intention to bar Longmont residents like the applicant from STR ownership when passing the STR ordinance, and the location of the proposed STR is not in a traditionally residential neighborhood that the ordinance was designed to protect and preserve." The new communication that was issued in advance of today's hearing did not repeat those admissions. That said, I could not have said it better myself. For all these reasons, we ask that the commission reverse the decision of staff and find that the denial of Ms. Tatey's application was incorrect and that her STR application complied with the STR ordinance and that she's eligible for a license. At a minimum, we ask the commission to reverse the denial, find that the decision was incorrect, and impose any reasonable restrictions on that application. Thank you for consideration, and please don't hesitate to ask if the commission requires any further documents or information.
Thank you, Mr. Wilson and Ms. Teddy. I'm going to consider this a public hearing item. It is optional for us. Commissioner Poland.
Do we have to move for that? Do we have to make a motion to allow it?
Well, to be perfectly thorough, we can.
So I will move that we allow a public portion, public to be heard for this item.
Okay, motion to have a public hearing on this item. Commissioner Height.
Well, second.
Seconded by Commissioner Height. We'll take a roll call vote. Commissioner Height.
Aye.
Commissioner Poland.
Aye.
Commissioner Kohler.
Aye.
That was
Aye.
yes? Okay.
Yes.
Commissioner Oneron.
Aye.
Commissioner Flagg.
Aye.
Commissioner Tedda.
Aye.
And I will also say yes. So that passes unanimously to make this a public hearing item. So we will proceed with that. Now, one thing we did not put in our motion was how much time to give them, but I believe that 2 minutes is too restrictive, as was suggested to us. I would like to up that to 3 minutes per speaker rather than the 5, which we normally do. Is there any commissioner who disagrees with me on that? Okay, so we'll go with 3 minutes. Dallas, if we can put the slide up, please. So if anybody would like to call in about this particular item, we'd love to hear from you. The information is being displayed on your screen right now. Please call 1-888-788-0099. When prompted, enter the meeting ID 868-6086-1062. When we're ready to hear public comment, we'll call on you to speak based on the last 3 digits of your phone number. Each speaker must state their name and address for the record and will be allowed 3 minutes to speak. Please remember to mute the live stream when you're called upon to speak. This does take us 5 minutes to do. We'll be back at 7:37.
Chair, we are about 30 seconds out from the 5-minute mark. At present, there are no callers.
Okay, Dallas, sorry, I was away from my desk just momentarily.
That's
So
okay.
no callers.
No callers. I will drop the slide.
Okay.
And you should be good.
All right, thank you, Dallas. We had no callers, so we will close the public hearing on this item. Before we go into our discussion amongst the commission, I'd like to just kind of review what our process is, and I do have a question for City Attorney Eugene May, because we don't do appeals that often, and the process is a little bit different. So we now enter into if you have those 7 steps, which Don Burchett put in front of us, and it's in our packet as to what the process is, we're at step 4, which is planning commission discussion and questions to all parties. And then there can be a rebuttal by the city staff or the administrative official, and then also by the appellant, and then further planning commission discussion. And if we ask further questions of staff, then there can be another round of rebuttal. My question to City Attorney May is, in this procedure, if there are further questions to staff, does that include you as the attorney who is representing the Planning Commission?
Chairman and Planning Commission, Eugene May, City Attorney. I would think generally not. In a quasi-judicial setting, it's about the evidence. And if you introduce additional evidence, then that would trigger the obligation to provide rebuttal opportunities for both the appellant and staff. Generally, advice from the attorney to the Planning Commission is not considered evidence. It would be more in a legal nature, interpreting code, statutory construction, those sorts of things. And though that's not really considered evidence, like factual evidence from the parties.
Okay, and then also, Attorney May, just can you explain to everyone that, because I just made reference to this, that you are representing the commission, but we also have our Assistant City Attorney, Atasi Babsar Titlo. Did I say that right? And can you explain her role, please?
Certainly, Chairman. So in this situation, the city attorney is representing 2 parties in this. I am here to advise the Planning Commission. Ms. Bassar is here to represent staff and advise them in presenting the staff reports. We create a confidentiality wall within my office when we engage in these sort of dual representations where myself and Atasi do not speak substantively about this matter. We may talk about procedural matters like the rescheduling of the past hearing just to coordinate, but nothing of the substance of the matter or the issues involved.
Okay, so if any commissioner has a legal question, needs legal advice, it'll be addressed to you, correct, Eugene?
Correct, exactly.
Okay. All right, great. Any questions from other commissioners about our procedure? Okay, thank you, Eugene. Let's go into discussion. Commissioner Height, can you turn on your camera? I keep thinking that I've lost a commissioner. Okay, great, thanks. Let's see. Anybody have any questions to start with? Commissioner Height?
Now that my camera's on and now I'm unmuted. Planning Director Longmont, in reviewing Section 1510, dealing with definitions, there's a somewhat of a catch-all. It provides for terms used in the development code that are not defined therein in the definitional section, which is 1510, or otherwise in the municipal code, get to go to you. for your interpretation, have you made an interpretation to the extent anyone's ever even asked you to do so, because I think there's a procedure to do so, as to what is a resident of Longmont? And then also note that in section 1502080D4, there is something called an official quote city of Longmont address. Have you had the opportunity, or have you otherwise provided your interpretation what those terms mean?
I've never been formally requested, but when this matter came up, I think I was the first one that thought, well, if you're a resident, you participate in the election process or in board and commission. And immediately I felt that they don't meet that test. But that, as far as I've dealt into the definition of a resident.
Attorney Mai, is it appropriate for me to ask Glenn now for his interpretation?
You can certainly ask questions of staff.
Okay, I'm just saying, it would be appropriate to ask him now for that interpretation. Now.
Yes, I think so.
All right. Director Nimwagen, what's your interpretation?
A resident is somebody who can participate in all the election processes of a local government. I would also say, are they a property? Is their principal residence, are they, do they pay property taxes? And in this case, no. So my interpretation is the appellant is not a resident of the city of or of Longmont.
And one more question I had for you. So in the provision regarding short-term rentals, section again, 150.02.080D, subsection 4, proof of residency, subsection, come on. Subsection A, applicant should provide the following showing a quote, official city of Longmont address. Do you have an interpretation of what an official city of Longmont address would be?
Well, it'd be an address that would be issued by the city of Longmont and not Boulder County.
Would it be within the corporate jurisdiction of the city of Longmont?
Correct.
Corporate boundaries? Okay. I have nothing further right now. Thank you.
Okay. Commissioner Poland.
Yeah, Dane, I'm just wondering if in the past, and I believe that this is still relatively something new for us, but have we ever turned down an application for a rental unit, whether it was because of the residence being rented or because the owner was not an official city of Longmont resident? Has that ever happened before?
There's one other case, I can't remember the address, but that resident also lived pretty close. She wasn't actually like this applicant was, where she's completely surrounded by city property. This one was just north across from Highway 66, across from the Walmart. But we did deny that one for the same reason.
Thank you.
Eugene May, I have a question for you. When we're faced with a term such as resident, and it's not modified by the word city, but that term is being used in the city of Longmont's code, how does the law look at how one should understand a word that has not, I mean, does a word like resident always have to be modified by the word city when it's being used within the city's very own code?
Commissioner Chernak, So there are a number of rules of statutory construction that are pretty well established when interpreting laws. And I think the first canon of statutory interpretation is plain language. You know, what would the ordinary person interpret that to mean? And then, you know, there's many other canons of statutory interpretation. If the plain language is clear and unambiguous, you should stick with that. Don't look at other things. Otherwise, other methods of interpretation, if it's unclear, you can go look at legislative history and the words around it, the context of the statute. And so, you know, to your question, I like to provide the standards to the commission and have the commission apply them. I think, you know, I don't want to offer my opinion, but I would say start with the plain language of the statute. If it's clear, that's the end of your inquiry. If not, then you would look at other surrounding words or the structure of the ordinance to try to get more information on what you thought or what you think that the city council meant when they passed that. And I hope that answers your question.
Yes, it does. It does give some guidance. Thank you very much. I'll put this out to the other commissioners, given what we just heard from City Attorney May. To my question, I cannot support the appellant's argument that the city should always be defining the term resident with the modifier of city in front of it, when we're using that word within the City of Longmont's code, on the City of Longmont's website, in the City of Longmont's ordinances. Everything is based, obviously, on the City of Longmont. So if we're saying resident, resident means a resident of the City of Longmont. It does not have to expressly state city in every single line of code, because it's understood we're talking about the City of Longmont. We're not talking about Firestone. We're not talking about Lafayette. It's Longmont. Who else would we be talking about? Certainly not Boulder County. So I personally reject the appellant's argument that the definition of resident is questionable because it was never modified, or not never, but sometimes not modified by the word city. Commissioner Poland.
Yeah, thank you. Yeah, and also in terms of that, when I'm looking through the conditions that we're asking them to meet, and I go to, and I'm just going to go to the 4A section IV 4, and then which is at least two of the additional documents indicating that either the short-term rental is the applicant's primary dwelling, or that the short-term rental is a resident of the City of Longmont's second or investment property. When I look at is resident of the City of Longmont, one of the things that it looks for is item B, which is proof of voter registration. To me, that indicates that the city is looking for a resident who can vote in the City of Longmont. So I would agree with your interpretation that, to me, the city's code, when I read it and I look at the A, B, C, D, E, when I look at B, it definitely shows to me that they're looking for a City of Longmont resident who can vote.
Okay. Mr. Hermsen.
I just wanted to clarify, we don't require voter registration specifically. That's one of the possible documents they can submit that shows their current address where they live.
Correct, but it shows there, also shows there's, to me, it's indicating one of the things the city is looking for is showing a residency in the City of Longmont. To define a resident of the City of Longmont, one of the things they're looking for is somebody who could vote in the City of Longmont. That's one of the, to me, it's to me that's going towards what is the city actually looking for.
Right. Okay. Mr. Hermsen, since you have your camera up, I have a question for you. there are other Boulder County enclaves within the city limits of Longmont. I live near one, and it's got a marijuana dispensary on it. As code enforcement for the city of Longmont, would it ever cross your mind that you could enforce code on a Boulder County dispensary? Even it's surrounded by the rest of the city, but it's not part of the city. So do you feel that you have any ability to project the city of Longmont's code onto a county enclave?
No, never. They're outside of our jurisdiction, and we can't enforce anything on that property.
Okay, thank you. To the commissioners, the reason why I asked him that question is because it appears to me, if I am understanding the appellant's argument correctly, they are saying that that Miss Teddy lives in an enclave surrounded by the city of Longmont. Therefore, she should be able to take advantage of the city of Longmont's short-term rental code. But the city would never occur to the city to say, hey, we would like to do some things on county land, such as the dispensary that's next to me, which the city, if that dispensary was in the city limits, the city very likely would have denied it because we have a restriction on how many dispensaries we have. So it doesn't go both ways here. You're either in the county or you're not in the county. You're part of the city or you're not. The argument that well, she's close enough to the city, therefore should be able to use some of the city's code to her advantage. In my mind, that is undermined by the fact that the city does not have any purview over county property. Commissioner Kohler.
Yeah, I guess I have a question. I'm not sure who's best to answer it, but if we're not talking about the city of Longmont, what border are we talking about? How else would Longmont be defined?
Do you want to address that maybe to Planning Manager Burchett or to Glenn Van Menwegen?
Sure, maybe Commissioner Burchett would be the best to answer that.
Commissioner Kohler, Chairman Chernak, I think that, as I understand, and I do not want to speak for the appellant, they would look at the Longmont zip code as a way to try to define whether a person is a resident of Longmont. Again, these are my words, not theirs. It would probably be good if they would explain their thinking, but that is my interpretation of what I read in the appellant letter, stating that they felt that we defined it too narrowly.
And do we have any other instances in the code that where it would apply to the zip code of Longmont and not the city? I'm assuming no, right?
None that I'm aware of.
Could we ask the appellant then, or their attorney, to possibly respond to that?
Sure. I was just going to check to see if you wanted to pose that to the appellant. Mr. Wilson and Ms. Teddy, would you like to answer the question?
I think we need y'all to start our video again, please. Or allow us to.
Dallas, if you could get their video turned back on for us.
It is available to them. I'm not quite sure why.
There we go. It's available now. One sec.
Yeah, thanks.
Oh, actually. All right, here we are again. With respect to the specific question regarding zip codes, that's one of several indications that Ms. Tady is a Longmont resident. Looking it up the way some of you might be by looking for the phrase zip code. in the Longmont Municipal Code. And before I get to that, the two phrases mean different things: resident of Longmont and city of Longmont resident or address. This ordinance was signed last summer by the former deputy city attorney, and words mean things. And when you're using multiple different phrases, it's possible they mean the same thing, but it's also possible that they mean different things. Seems most intelligible to me that city council meant two different things by Longmont resident and city of Longmont resident, or else why wouldn't they say the same thing in each instance? There was a proofreader on this ordinance, and it was presumably duly vetted. There are numerous meetings discussing the precise language of the ordinance, what activities would be permitted and which would be restricted. And before I move in, and I'm going to try to avoid making sort of responding to each point that's been raised so far. But without having a cite to the code at hand, I think this is pretty good evidence. I don't know if we can see this, and I didn't provide it beforehand, but Longmont CO 80503. That's where Ms. Tatey lives. And I think that to assume that the ordinance meant to, or actually does, mean a resident of the city of Longmont rather than someone who lives in Longmont, as the term is commonly understood, is an overly technical reading and superimposes words that aren't there into the ordinance. And respectfully, I don't believe that's legally permissible, although I agree in general with City Attorney May's statement of some of the canons of statutory construction, which are all applicable to a municipal ordinance like this. Her utility bills are issued by the city of Longmont, paid to the city of Longmont, mailing address, city of Longmont, driver's license that you just saw states that she lives in Longmont, Colorado, 80503. And, there are some reliance issues here also, because this property was purchased as a rental property. And, the construction of a statute or an ordinance, as City Attorney May, I'm sure can confirm for you, is a matter of law. There's not really, there's a right way and a wrong way. And if there is even the suggestion of ambiguity, the law requires it to be construed in favor of the property owner and of the free use of property. So it's a little bit of a rambling way of answering the question. I don't have a map with the boundary on it for you, but I don't think we need one in order to make this decision correctly tonight. Thank you.
Commissioner Kohler, do you have any follow on?
I have an additional question, not necessarily a follow-up. So if she doesn't pay taxes in the city, but the rental property is, I assume the taxes for the short-term rental, they follow the rental, not the ownership. Is that correct?
That's correct. They pay lodger's tax like any other hotel within incorporated city limits.
But she doesn't pay the city of Longmont tax based on her residence where she lives now.
Correct.
Okay. No, I don't have any further questions for now.
Okay. Thank you. Commissioner Oneron.
Well, this is a tough one. I agree with a lot of the interpretation about the word and the common meaning of the word. Chairman Shornack, you talked about the dispensary example. I think that example is kind of irrelevant because we're trying to understand the meaning of the rule. The rule could have been easily said 30 miles in proximity. Then we're really expanding. That is to say, the city is allowing or regulating something that is happening within the city limits, but then the language can extend to larger residents. So what I'm struggling is to really understand the intent of this particular rule. And that's why, I'm really hesitating to really jump into the conclusion easily. To me, yeah, Longmont resident means city of Longmont, but at the same time, did really council thought about this as the city? That is, I see the argument of proximity and I see the argument of, distant, we're trying to prevent the distant ownership. And so I haven't made my mind up, but I'm really struggling with those two issues. That is to say, the common meaning of the term, but also the intention of the rule. Because at the end of the day, when we ask ourselves, how do we interpret a rule? It's the intention that matters. So for the time being, that's all I want to express.
Thank you. Commissioner Flake?
Thank you, Chair. I don't know to whom I would direct this question, but I know I live in a zip code that is shared by Firestone. So can I then go and claim residency or particular benefits in Firestone? See, I think I know that the post office decides on zip codes and what their boundaries are. And that has caused for many jurisdictions no end of discussion of whether a person within a zip code is also within a city. And to the best of my knowledge, and I admit I'm not an expert, it would seem that where I pay my property taxes or where the abode in which I live, where the property taxes are paid, because I could be in a rental, and that would determine in which jurisdiction I reside. That would seem appropriate to me. And the other part is that I think I was on this commission when we worked on this matter and discussed it at length, and the reasoning for putting the requirement that people who own such a rental property for short-term rentals be within the city, so that, yes, they would be available and they would have a vested interest in how the short-term rental was rented out, who stayed there, and how it looked over time. I do have a question for, I think, Don Pritchett. I understand that even if it's not a short-term rental, to the best of my knowledge, would it then still be able to be rented out? So that there would be some benefit to the owner of the property.
Commissioner Flake, Chairman Chernak, the regulation would not preclude any rental over 30 days or more. So you could do what I would term a long-term rental or a month-to-month lease or a year lease. So there would still be the opportunity to lease the property to generate income on the property.
Don, while you're there, and maybe this is also Mr. Hermsen, is Commissioner Flake correct that zip codes are established by the U.S. Post Office? And does the city have any input as to what is included in a zip code or not?
It's my understanding that the zip codes are determined by the post office, and I believe the postmaster get together and work on determining where those boundaries were back in the day. And they do cross county lines. They go into other cities. When cities annex, we do not have to annex into, or we're not precluded from annexing into another person's zip code. So we could annex, for example, into Firestone. Firestone has annexed into the city of Longmont or into our zip code. There's nothing to preclude that. And
Okay.
Was there another question there? I'm sorry.
No, but I have more. So in a similar vein, how does the DMV determine what somebody's address is on their driver's license? And does the city have any input into that?
I've never had a contact from DMV, so I can't. I would be making an assumption that it's based on your mailing address of where you live and where you receive your mail. but that is an assumption on my part, just of what I've had to prove to get licenses renewed or new licenses for my kids when they have become of the age of able to get a driver's license.
Sure. Dallas, we just lost somebody from the meeting. I think it's Commissioner Poland.
Seeing that, we will try and contact him real quick. And I will
Okay.
unlock it. So if someone,
And we're going to pause until Commissioner Poland is back. I don't want any commissioner not being part of the discussion. Sorry, everybody. When this happens, it takes a little bit to get the person back.
I've just sent him an email with the invitation, but if anyone has a phone number or contact number for him, in case he lost power or something along those lines and wants to contact him, that would be great.
Jane, do you have his contact info?
I don't have it right offhand. It might take me a couple minutes to find it.
Okay.
Sure, Nick. While we're waiting, and I believe this discussion point is not substantive, but it gets back to the process, which is how we are proceeding here. Which we open it up for a public hearing. None of the public decided to participate. As I look at what we're doing now, we are having discussion and questions of all parties. We're not necessarily deliberating. Is that your understanding?
Right, we're having a discussion, and yeah, we're on item 4, planning commission discussion and questions to all parties. Yeah.
Okay.
So we have not yet had rebuttals.
Got it.
Okay, looks like he's coming back.
With his hand raised.
With his hand raised. All right. Actually, I still have a few more questions, and then we'll get to Commissioner Poland. Don Burchett, can you explain, I know that there's been a fair amount of development history. Ms. Teddy lives in the Schlegel neighborhood. Can you explain to me, why does the unincorporated Schlegel neighborhood have its utilities provided by the city of Longmont, and why would she be paying her utility bill to the city of Longmont?
That's one of the few subdivision that was built before I started. So I probably am not going to be able to give you the right answer, Chairman. I could wager a guess, but I would be guessing, and I don't think that's fair.
Okay. Would it be, let me phrase it in a more broad sort of question. Does the city sometimes provide utilities to addresses that are not officially in the city of Longmont's boundaries that are in unincorporated parts of the county?
Chairman Chernak, we do. Yes, we do.
Okay, and if we provide utilities, then that address and that property owner pays utilities to the city of Longmont. But are they therefore a resident of the city of Longmont because they're paying for gas and electric, or not gas, but electric that they used from us?
Chairman Chernak, they're not considered a resident, no.
Okay. I have more questions, but we have more hands up. So Commissioner Poland.
Thank you, and I'm sorry about that. I had that nasty old computer battery run out. Real quickly, Don, can you explain what the difference is between having a Longmont mailing address versus being a city resident is?
So again, this is my understanding is that a resident of Longmont is someone who lives within the corporate limits of the city of Longmont. They pay taxes to the city of Longmont. Someone who has a Longmont address could live in any of our zip codes that were determined to be considered Longmont by the post office. We have no say in those.
Okay, and I also do want to make note too that I did come across this a few years ago in looking at our the residency requirement to serve on a board, committee, or commission. It does say live in the city of Longmont for 1 year, and I do know that that does not mean have a Longmont mailing address. That it means being in the incorporated Longmont area, actually. So just wanted to also make note of that.
Okay, Commissioner Height.
Thank you. Attorney May, Attorney Wilson raised an issue regarding interpretation of legal standards and what's the appropriate legal requirement. And when I start looking at the level of review that was referenced in our packet, I think it's 1502040K8, appeals of decision, final actions by the director or staff are made to planning and zoning, where we hold a de novo review. I think I understand what de novo is, but could you, Attorney May, explain to the commission what de novo review entails?
Certainly, Commissioner Height. De novo review means anew. So you are not bound by the previous interpretations of the planning director, and you are able to receive evidence and base your decision on that new evidence presented at this hearing.
So to be more specific, I asked planning director Nimwigan regarding his interpretation of what a resident of Longmont, what that term meant, what an official city of Longmont address meant. We're not bound by that. We, the commission, gets to make its own determination, which is subject to review for abuse of discretion. But we get to make our own decision as to what these terms mean. And that's what we're asked to do tonight, correct?
Correct. At a de novo hearing is anew.
Great. And that's all I had.
Commissioner Kohler.
Yeah, I have a question, I think, for Planning Manager Burchett as well. In the STR requirements to, or I guess the definitions to provide proof of residency, based on the discussions tonight that we've had so far, I don't see how any of those by themselves would prove that they live in the city of Longmont. One is proof of a valid motor vehicle registration, proof of a voter registration, federal or state tax returns or other financial documentation, a utility bill. I don't see how any of those on their own, they could all say, the appellant has a utility bill, that's City of Longmont. She has a driver's license. How do any of those show that you're actually in this city?
Commissioner Kohler, Chairman Chernak. The documentation that we've asked for are common items that would be official documents that would contain an address that the person has stated as their official address. We would then use that and look on the city's website or our Boulder County tools through the Boulder County assessors to determine whether or not that address is within the city of Longmont. So that just gives us proof that the person who's claiming to be a resident of Longmont has an address that's officially recognized by more than one group as their official address. And we're then using that to confirm whether or not they're a resident.
Okay, thank you.
I have a question for our council representative, Council Member Rodriguez. Commissioner Oneron brought up a very good point. My dispensary example was not the best. And Commissioner Oneron pointed out that the issue of proximity is really what's at play. What can you tell us about the city council's intention? As Commissioner Oneron pointed out, we need to know the council's intention. What was your intention about proximity? And what does the council, shall we say, view as the driving intent, the primary intent, the most important reason as to why the STR property owner needs to be a resident of the city?
So I think it's somewhat inappropriate to talk about a previous council's intent because we've gone through an election cycle. And I do not have the ability to talk about the current council's intent when we are speaking on this, as well as it's not really appropriate for me to speak on the previous council's intent in the sense that I'm one of 7 voices in that, I guess, decision. What I will tell you is that the council wants to ensure that we do not have folks that also have Longmont addresses who could be, say, based in Gun Barrel, for instance, because there are Longmont addresses in Gun Barrel. These are United States Postal Service decided addresses. We have Longmont addresses in Frederick and Firestone, if you will. And so we're trying to ensure that we do not have folks who are, say, running for council, because we've heard allegations of that for folks that live in Frederick and Firestone. And we've seen similar kinds of techniques based out of folks that live in places that are unincorporated, such as portions of Gun Barrel, general other unincorporated places in Boulder County, as well as Weld County. So I think that if we're really going to talk about council intent, we need to have the council's input on that, not just the liaison for this circumstance. Thank you.
Thank you very much. Commissioner Kohler.
Sorry, I just forgot to lower my hand.
Okay, all right. More questions?
I guess I do have one more.
Yes, please go ahead.
So given that they've had at least one denial before of the previous situation, and then we have this appeal, has staff had any discussions on clarifying the definition in the text, or maybe related to any other issues like this within the code?
Commission, excuse me, sorry, Commissioner Kohler, Chairman Chernak. You know, the code itself, as we use the code, there's always items that we find that need to be additional clarification or minor revisions in order to ensure that we have consistency and that it's clear for everyone. You know, as I've gone through this in preparation for this meeting, and looking at it, I do think there are some things that we should clarify in this to clean up some of the ambiguities that have been pointed out in the hearing by the appellant. Personally, I don't think they're ambiguous. I think that, you know, it says a resident of Longmont, and I think that's pretty clear. But if, you know, we believe that there are things that should be cleaned up, then we would do that. But right now we're not looking at making changes to this section. We believe it is clear.
Okay. Commissioner Poland, did you have a question? Saw your hand up earlier.
Yeah, no, I was thinking about, but then not going to ask it. So.
Okay. I have a question for City Attorney May. Eugene, as our council representative rightly pointed out, he cannot speak on behalf of council and a prior council and their intent. How do you advise the commission when we are trying to think about council intent? Are we restricted to looking just at the code of the ordinance? What?
Chair, in this circumstance, the overriding concern that I see is that the commission make its decision based on evidence presented at the hearing. Legislative intent in our legislative process are primarily council communications from when the ordinance was passed by city council, and then the discussion of city council at that time. You know, that evidence has not been presented at this hearing. Maybe it's something in future hearings that the commission may be interested in being apprised of or contained in the packet. But, you know, given where we are tonight, right now, it would be difficult to discern legislative intent based on the evidence and the staff present.
Okay. Then I also have a question. I'm not an attorney. And Mr. Wilson presented a principle of law from 1882 about finding in favor of the public. I'm wondering, Attorney May, could you give me your interpretation of what Mr. Wilson is referring to?
I think it was the principle that there should be free use of property. If there is ambiguity, I have to say I don't know that case. There was no brief provided for review. These are just citations, you know, verbal citations that I'm not familiar with. There are a number of different principles, I think, applicable here. We went through some of the statutory interpretation type principles. There are certainly common law and other statutory principles regarding the use of real property. And I think that the commission would consider all of those for making its decision. I mean, it goes into the mixer, and if staff would like to rebut, that's an opportunity to hear another viewpoint. I don't think it's really my role to address particular arguments made by the parties.
Okay. Thank you. Further questions before we go to rebuttals? Commissioner Poland.
Yeah, I guess what this boils down to me is in 4A4, where it talks about the pieces of documentation at the short-term rental as a resident of the city of Longmont. I guess it comes down to what we interpret as the resident of the city of Longmont. And to me, does that mean she can be a resident of unincorporated Boulder County, where there are certain jurisdictions and certain code that she meets to do certain things on her property? And can then she also be a city resident of Longmont, where there may be conflicting codes? For instance, if she wanted to rent her primary residence right now, would that be considered a city of Longmont, a resident of the city of Longmont, or would she be considered a resident of unincorporated Boulder County? Or does she get to pick and choose which one? Because obviously, to me, she's first a unincorporated Boulder County resident, and that would take the primary jurisdiction. But that's just my thoughts. Like to hear some other thoughts on that.
Okay, well, we might get to that deeper discussion after the rebuttals, but Commissioner Height.
So I was going to say, before we start going down that rabbit hole, I think we need to listen to the rebuttals.
Okay. Before we discuss Commissioner Poland's point, we'd like to go through rebuttals first. Let's see. Okay, we will do the rebuttals in the order that the presentations were done in. So city staff will rebut first.
Thank you, Chairman Chernak. Dane, do you have anything that you would like to get into the record first before I go?
Nothing to add.
Okay, thank you. I have a few things that I'd like to point out and make sure that the commission has an understanding of. First, I believe the ordinance is clear. The term that is used is resident of Longmont. That is the question that's here. There is another term, Longmont resident, but it's used in a different section, and it's used to determine whether or not a person is a real person, so that a corporation can't own a property and claim to be a person. Attachment 6 in the council communication, which is a printout from the Boulder County website, which shows, I'm going to try and hold this up even though attachment, again, 6 is in your packet. There's a map. It shows the location of the applicant's residence, the primary residence. Shows that it is not located in the city limits of Longmont. It is in unincorporated Boulder County. And it also says what jurisdiction it's in. And it says jurisdiction, unincorporated Boulder County. It does not say Longmont. It doesn't. So when we look at the information that we have available to make the determination of whether or not this is in fact a resident of Longmont, Ms. Teddy is not. And we don't have the ability to interpret it in the way that she asked us to. So it was denied. And that's all that I'd have for to you. Thank you.
Thank you, Don. Mr. Wilson and Ms. Teddy, if we could have your rebuttal.
Sure, and before we deliver that, I just want to thank the members of the commission and everyone present tonight for your time and consideration. I touched on this in response to a question a little bit earlier, but all of the evidence needed to rule in Ms. Teddy's favor is in the STR ordinance itself. It says two different things: resident of Longmont, resident, but there's a third phrase or a third meaning, which is separate and distinct from both of those, and that's a resident of the city of Longmont. And in the ordinance itself, that appears in two places. First of all, the STR property has to be within the city of Longmont. And then there are also options for factors, documents that could be considered as sort of a factor test. No one document is dispositive, showing that an STR belongs to a resident of the city of Longmont, but it doesn't appear anywhere else in the ordinance. And I think we've already heard in some of the discussion just now, at least an understanding or a consideration that maybe the ordinance could stand to be cleaned up a bit. I also heard directly some of this ambiguity. And I seize on that because there is no question with respect to the governing law that if there is ambiguity, the ordinance has to be construed in favor of the property owner and in favor of the free and unrestricted use of property. That's binding Colorado Supreme Court precedent. And respectfully, all of this, we've talked about a few different issues, peeled this onion a few different ways, talking about zip codes, which are of course assigned by the post office, driver's license. Gosh, I don't remember the last time I filled out an application. Must have been when I moved to Colorado 15 years ago. But none of those are dispositive at all. I mean, as City Attorney May noted at the beginning, I believe, and correct me if I'm wrong, I know someone mentioned it, and I agree wholeheartedly that the analysis ideally should begin and end with the plain language of the statute or the ordinance. In this case, there are several different phrases being used, and presumably words meaning things, those phrases need to mean different things. It's possible that there could have been a proofreading error, I concede, as between the phrases resident of Longmont and Longmont resident. I can't really form a principal distinction between those two, but as between those two and the definition of a resident of the city of Longmont, that is a different thing. There's no question that the Emery House is located within the city of Longmont, and we didn't get to the point where the commission or staff or anyone else could have weighed in on what forms of proof of residency might be required of someone who lives in Longmont, but not within the corporate limits, such as Ms. Tate. A couple of individual concerns that I would like to respond to. Besides that, we did have some discussion about the purpose of the STR ordinance and about how there is and was a valid concern, in my view, that the property owner who has an STR license, owns an STR property, be invested in Longmont. There is no doubt that Ms. Tate is invested in Longmont. She's already invested more than $30,000 in improvements to fix up the Emery House. In contrast, next door to the Emery House, there's a long-term rental, not subject to this ordinance or any of these debates, which is in severe disrepair. And a dead tree fell off onto her electric box a couple of weeks ago, sometime in the very recent past, caused thousands of dollars worth of damage. So when we talk about the policy of being invested in Longmont as a prerequisite for obtaining an STR license, we agree wholeheartedly. And we don't believe that any perceived lack, first of all, there's no principal distinction between the investment of a short-term rental, owner of a short-term rental property, and the owner of a long-term rental property. And in the case of this exact block, it's actually the opposite. There are no requirements like this for a long-term rental. Anyone can buy anything and rent it to whomever. And there are legitimate concerns about responsiveness, availability, those sorts of things. Those have all been met here. There's been no evidence from staff regarding their thought process as to the determination that Longmont resident or a resident of Longmont meant resident of the city of Longmont, where that language doesn't appear in the ordinance. Respectfully, it seems like we're after the fact talking about what they might have thought, but as City Attorney May noted in a de novo hearing, this is a new record, and the decision should be based on the evidence and argument presented at the hearing. And frankly, there's not enough information on the record anywhere to know what staff thought when they denied this application. I mean that with all due respect, but there's no meaningful way to know what they meant, and we haven't heard any evidence tonight that provides any compelling basis for how these three different phrases somehow all mean the same thing. With respect to, we've also talked about investment in the community through the form of payment of taxes. And it's ironic because what Ms. Tatey is asking for here is to obtain a license which would allow her to pay taxes to the city of Longmont. And the options are, a short-term rental license, in which case the city would receive, a percentage of it through lodging tax, and a long-term rental license, in which case the city would not receive anything like that. Just one moment, please. Just want to make sure that I've mentioned everything that I meant to. I think I have. I just think, in conclusion, respectfully ask that the commission resist the temptation to superimpose language onto the ordinance that's not there, to take a hyper-technical interpretation of one possible form of proof of ownership, such as a zip code, such as whether or not she's running for city council. Those are totally separate issues and respectfully not at all relevant to what we're talking about here. Ms. Tatey would like to take the opportunity to speak directly to the commission for the remainder of our rebuttal. And again, thank you all for your time tonight and for your attention and care to this matter.
Thank you, Commission. Longmont is where I work as a small business owner. Longmont is where I play and recreate. In short, I am a proud and invested resident of Longmont with exactly the type of commitment to the community and immediate access to my STR that City Council designed the STR ordinance to encourage. Based on the language that was available, I invested in a property, pursuing an opportunity to not only make additional income, but to share everything I love about my community with visitors to Longmont in a way that supports locally owned small businesses and restaurants. I believe in Longmont and have invested in the city as a result. I plan to operate in a manner that is beneficial and respectful to fellow members of the community that I am a member of and in which I myself live. Thank you. And I just might add that I have lived in a number of places, and I just want to thank Dane and Dawn for their kindness throughout this whole process. And I don't think I've ever encountered city employees that were as helpful and friendly as them. So thank you to both of them.
Thank you very much, Ms. Teddy and Mr. Wilson. We are now in number 6 on our procedure planning commission discussion. If we ask further questions to staff, then we would have another round of rebuttals. Doesn't mean we can't ask questions to staff. You're not precluded from doing so, but then we will go through more rebuttals. Let's proceed with our discussion. Anybody want to kick it off? Commissioner Haight.
Oh, if I can unmute myself, lower my hand. So looking at what we've been presented holistically with a fresh look, we're being asked to, by the appellant, to agree with her that the terms used in the short-term rental statute are ambiguous. Specifically, that the term in section, I guess it's for the record, 1502-080D2B, the entire dwelling unit constitutes second or investment dwelling of a resident of Longmont, is ambiguous vis-a-vis the language used in subsection 4A4, which requires showing documentation indicating that the short-term rental is the applicant's primary resident, or that the short-term rental is a resident of the city of Longmont's second or investment property. So the two terms are, one, whether or not it's a dwelling of a resident of Longmont versus whether or not the short-term rental is a resident of the city of Longmont's second or investment property. The language is not exact, but I'm not convinced that the use of the inexact language means two different things. To me, the clear intent of this statute, this ordinance, is to require that a rental property, a second non-primary resident property that's going to be used for short-term rental, has to be owned by a resident of the city of Longmont. I'm not so sure that it's inartful the way it's presented, but regardless, it's clear to me that a person who is not a resident of the city of Longmont cannot own a short-term rental or cannot be granted a license for a short-term rental within the city of Longmont. So I'm going to have to vote to uphold the determination of staff and deny the appeal.
Commissioner Flake.
When I heard the rebuttal, and I know that Planning Manager Burchett pulled up a sheet illustrating or showing, basically, if we could have seen it, exactly where the property is located. I've had some familiarity with working with property searches in Boulder County for my own purposes, not relating to this property. And since staff has done their research and can verify where the property is, and indeed it is not within the limits of Longmont, I think I have to, again, support staff decision.
Commissioner Unruh.
Well, hearing from Attorney May made me realize that, you know, the code language itself is the only way we can interpret the intention behind it, because, you know, we cannot ask the council, I mean, even though it makes sense in terms of planning wise, but the code used the Longmont resident. It doesn't provide a map. It doesn't talk about proximity. It doesn't give a mileage. It says Longmont resident. And that kind of limits our focus on the language itself. And when I'm confronted with that, I agree with previous comments that that means the city of Longmont resident. That is to say, that's the right interpretation of that term, in my opinion. And even though I sympathize with the appellant a lot, in this particular case, I need to agree with Commissioner Height that that's and Don Burchett about the interpretation of the term.
I'll add my 2 cents that I also feel for Ms. Teddy in terms of, I absolutely don't doubt her intention of being a really great person who works in Longmont and has bought this property and wants to do good things with it. But there is a slippery slope problem we're faced with as well. And I think this becomes really clear just how slippery that slope gets, given what we learned about the zip codes. If we were to open up our permits for an STR to somebody who is proximal to Longmont or has a mailing address with a Longmont zip code, or one that's considered a Longmont zip code, then it actually turns out, as we learned from Councilmember Rodriguez, that could include people who are living in Gun Barrel and in parts of Firestone. And that is what I mean by a slippery slope. Ms. Teddy is correct. She's very close. She's very close to the property that she bought. But if we were to give her an exception, then I think it will open floodgates to many other people asking for a similar exception, and then we've lost the purpose of the ordinance, which is to not have absentee landlords. Commissioner Onaran, another question? No, just
Sorry, I forgot to
okay.
lower the hand. Sorry.
All right, Commissioner Teta.
So I'm personally very sympathetic to the applicant. I would like to think that the intent was to keep outside interests from owning properties that were turned into short-term rentals. And I'd like to think that we could consider the greater Longmont area. And if you lived in Gun Barrel, for example, I think that would in fact be close enough. I mean, I realize that this requires revisiting the code, but we were part of the code construction, I think, to begin with. And I'm not convinced that it was the intent of anybody who wrote the code that the primary resident had to be within the city specifically.
Commissioner Poland.
Thank you. As we talked about it, it's the simplest reading of the term, and I agree with Commissioner Height. Whether you go to 1502.080 D2B or you go to 1502.080 D4A subsection 4, the term, whether you say resident of the city of Longmont or resident of Longmont, to me, it's both clear that we are looking for somebody who resides within the incorporated area of the city of Longmont. Whether that's right, whether that needs to be reevaluated at some point, that's not our determination. Our determination is reading what the code says, and based on what I read, the way I interpret it, the simplest way means that it's a resident of the city of Longmont, which means somebody who is incorporated in Longmont. So I would be in favor of upholding the planning commission or the planning's refusal of this.
Commissioner Kohler.
Yeah, I'm going to have to agree with the other commissioners. I do think that the code applies to the city. Just as you, Chairman Chernick, mentioned, we wouldn't be able to apply code to unincorporated Boulder County residents. So it doesn't seem like the opposite should be true. I think the city or the council intended that this apply to the city of Longmont. Now, personally, I think that should be revisited. I don't know that this is the right answer to have someone who's, but for all intents and purposes, living in Longmont, recreating in Longmont, to not be able to take advantage of this. But I do think it's what the code requires. And so I do hope that if this is revisited, that the appellant would reapply and try again then.
Thank you. Commissioner Poland.
Yeah, thank you. At this time, based on the discussions we have, I would move that we approve PZR 2021-13A.
Okay, we have a motion to approve PZR 2021-13A, which, to be clear, would uphold the denial of the STR license. Basically, it's agreeing with the planning director's decision. Do we have more discussion? Do we have a second? Commissioner Height.
Well, second.
Okay, Commissioner Height has seconded Commissioner Poland's motion to approve PZR 2021-13A. Any more discussion amongst the commission? Okay, seeing none, let's take a roll call vote. Commissioner Height?
Aye.
Commissioner Flagg?
Aye.
Commissioner Teta?
Nay.
Commissioner Kohler?
Aye.
Commissioner Onaran?
Aye.
Commissioner Poland?
Aye.
And I will also vote yes. So Jane, that passes 6-1 with Commissioner Teta
Dissenting.
dissenting. Thank you. I couldn't remember the word. I do not have a process statement that gets read at this point. Mr. Wilson, Ms. Teddy, thank you very much for coming and explaining your appeal to us. We wish you well. We have more to our agenda, so we will continue on with that.
Thank you.
Thank you.
Thanks again. We're moving on to item 7A, which is our electronic participation policy discussion. We all received this in our packet, and then we also received an updated document from Jane by email, which you all should have. Commissioner Height, would you care to walk? I believe you made some of the edits in what Jane sent to us. Would you care to walk us through that?
Certainly I will. And I apologize, JCH version 2. I did not realize at the time that version 1 had already been included in the packet. So we don't really need to pay attention to version 2. Back when we were first going to discuss this, maybe in the spring or summer of this year, what we were going to do with the continuation of COVID and how we were going to conduct meetings electronically. We needed to develop a process to do so. I'd written version 1 of my comments to send to then Assistant Attorney or Deputy Attorney Teresa Tate with some comments of what I thought she might want to take a look at and change this document around. But it encapsulates what I think we might want to address to the extent that this document can be, I think it was originally prepared to apply to all commissions. And if we can adopt it just for planning and zoning, these are the things that I thought we would talk about. Specifically, if you pull up the first document, not version 2, but the first document, in the statement of the general policy, subpart 2, subpart A, we get to make a determination of when we're going to have this electronic participation meeting for good cause shown. I think we should backtrack into that by having a certain number of days by which we're going to make that determination. Sometimes you probably can't do that if it's truly an exigent circumstance. There's a tornado and we can't meet, or there's a tornado that knocks out the whatever. The building gets knocked down and we're going to have to meet somewhere else. Otherwise, we should make this determination a certain number of days beforehand. So I had added a placeholder, so to speak, for the possibility of discussing, determining, what would be the number of days by which we would make this determination, and how would we meet this number of days beforehand? Would we email? We're not really supposed to have a meeting more than 2 of us without notice, but we have to make this determination. I thought possibly we could just delegate the determination to the chair. Could the chair make this determination? So that's what's going on in subpart A. Section 2, subpart B, the technology needs to allow everybody to hear, at least hear and see. I guess we like, but do we absolutely have to have that? What do we think about? Do we have to be able, does it have to be audio and visual? This electronic participation. We should think about that. Subpart C, everyone should be allowed to speak. There might be more than speaking that's involved. Participation sometimes includes making an audio visual presentation. There's, we have, slide decks that are routinely presented to us. do we should encourage that, but do we have to? Is the meeting no good if we can't allow someone to present their PowerPoint presentation? And another thing to think about. D was to allow the public to oversee what we do. It's a public meeting. In days of yore, people could come to city council meetings and watch us if they wanted to. We were on television. People could watch us on television. I think we're on television now. So I'll make sure that the technology allows that to occur. E, votes by roll call. We do that already. Minutes, we do that already. So G was what notice came out. Again, was there a time period by which we have to give notice before we have this electronic participation form of meeting? What that notice needs to require. Subpart 3, I really just tried to make it more consistent with what happens now, which is that, our recording secretary, Jane Madrid, reaches out to us and says, hey, we're going to have a meeting next week. Here's the packet. Please let me know if you're going to participate. We indicate back to her, yeah, I'm going to be there. No, I'm not going to be there. The day of, the IT coordinator, Dallas today, sends us an email of how we're going to participate, or an email link of how we're going to get into the meeting. I just tried to make subpart 3 consistent with those issues. And again, to prevent tampering, to allow an ability to get back into the meeting like Commissioner Poland had to deal with this evening. So those were my comments to our electronic participation protocol.
Anybody have any thoughts or? Actually, Glenn and Don, quick question for you. Do we need to approve a version of this tonight? Are we going to have a problem for January if we don't come up with something tonight?
Maybe I'll ask Jane. I think we are still under the previous policy, or was that determined we had to determine an emergency in order to use it, or Eugene would probably give us a good answer on that.
Commission, Eugene May, City Attorneys. So the board and commission electronic participation policy sort of followed what council was doing. The council electronic participation policy was implemented in response to the global pandemic for COVID. It was triggered by a declared state of emergency disaster. That determination or declaration was rescinded by the city manager sometime in the summer. So Planning and Zoning Commission, I understand, has been operating remote for several months with a new policy under consideration. I think that this policy would establish the expectations and put into practice what the commission has been doing. I think for open meetings purposes, open meetings law purposes, open meetings law specifically contemplates electronic meetings. And so we aren't in violation of state statute. And, if you want to get technical, if you have an ordinance or a policy under consideration, you can act like that while the formal process takes place. So short answer is no, I don't think you're in trouble. If you meet in January or today or tonight electronically, I think it is best practices to have an electronic participation policy in place, creates expectation for the board members and the public, on how these meetings are going to be conducted. But from an open meetings perspective, I think we're fine.
Okay, thank you. Commissioner Poland?
Thank you. So Commissioner Height, I really think to me, the one thing to be discussed is on section 2A, where it says number of days prior to meeting, exigent circumstances. So is that like basically part A and part B, where we can say, if we decide that we need to have this meeting electronically, we need to provide 7 days, 14 days, whatever the notice is, or if there is an exigent circumstance that eliminates the need to do a number of day prior notice? And does exigent circumstance mean weather related? Does it mean a health issue like COVID?
So a couple things. Yeah, it does mean that we should pick a number of days before our hearing by which we're going to make a determination if we're going to have electronic participation. If we're going to adopt electronic participation in response to something that we think is going to be long-term, i.e. like the pandemic has turned out to be, we might want to set that date in our initial determination. Exigent circumstances, in my mind, are things that are completely unexpected and immediate, to which you need an immediate response. So COVID kind of turned out to be a little exigent. In February of 2020, we had to do something. We weren't allowed to meet together. We had to figure out a new way to participate. Other circumstances that are going to be exigent, weather, or the building gets torn down by a tornado, are going to be circumstances where we're not going to be able to meet anyhow. We're going to have to come up with a whole new way of meeting. So yeah, I don't know if that answers your question. Exigent meaning something that requires an immediate response.
Well,
in which case you're not going to be able to make a determination 7 days in advance.
Right. So I guess that begs the question, if we have an exigent circumstance, would we still want to follow through with the meeting?
Probably not, right? Because
yeah, so let's say there's a tornado in the area. Do we really want to do we still want to have our meeting, or are we able to go ahead? I guess that's a question to maybe City Attorney Eugene May. If something like there's a tornado warning, are we allowed to postpone our meeting?
Commission, I think the first consideration is the safety of the board members, and not to be cavalier, we'll deal with the rest later. What judge is going to ding you for canceling a meeting, a posted land use application if you feel your safety is in danger? We would certainly support the board in doing that. And I think you raise a good point on it's hard to imagine all the exigent circumstance. We had the big flood, we had COVID. I don't think any of us were thinking either of those events were going to.
A snowstorm. Yeah, a snowstorm.
In the manner they did today, we got, hurricane force winds out there. So I do think it's a policy decision by the commission, and the direction from city council and the city clerk's office was let the boards decide what makes the most sense for them.
So and I guess then for me, the number of days prior to the meeting, if it's not an exigent circumstance, to give the public good notice, I'm thinking, 2 weeks? Does that sound about right? Thoughts?
Sounds about right to me, but Jane, Glenn, Dawn, in terms of noticing and making sure that the process can be managed?
From my end, noticing wise, I'm required to notice it in the newspaper, Times Call 5 days prior to the meeting. So, I mean, we could go up, we could make a decision up to that point and notice it. Other than, I shouldn't say that because we do have our notices that go out, public hearing notices that do go out 2 weeks before the meeting. So that's probably a good time to decide, you know, whether you're going to meet virtually or in person. And then again, if it's an emergency, like you've talked about, that would change everything anyway. So.
And Commissioner Poland, when you say 2 weeks, do you mean calendar days or business days?
Calendar days.
Okay.
Yeah, I think if Jane has a 2-week deadline, that probably should be our deadline too.
Mhm. Personally, I mean, Commissioner Height, I think your edits are spot on. I don't have any issue with them. What I think we could do is, I don't think approving something tonight on a version that I'm looking at that has multiple red line comments would be appropriate. Instead, it'd be nice to see a cleaned up version come in front of the commission in January. And January is when a lot of housekeeping work is done anyway. And I would suggest that the commission would take a vote on a cleaned up version at January's meeting. Any thoughts on that?
I would be acceptable to that, yes.
Eugene, I don't really want to own this document any more than I already do. Do you have staff that could finalize it?
We certainly do. We could take it from here.
Perfect.
Okay. Any more thoughts or comments about it? Otherwise,
Mr. Height, did you send us a Word red line version?
I can. I think I
Yeah.
sent my last version to Jane was by Word. I think.
Okay.
Jane, yeah. I'm pretty sure. Yes.
Yes,
We'll
I
figure
think it was.
Okay. Oh, by the way, just there was one point, Commissioner Height, you asked about whether the commissioners should be visible, should be seen during the meetings if the meetings are electronic. My opinion is yes, because I think it's important for the public to see that we are attending, that, I mean, literally have our attention. I can turn off my camera and sit on the other side of the room and have this going in the background, but that's not really attending to the meeting. So I think having cameras on really is an important thing here. So shall we pass this off to the city attorney's office? They'll clean it up and bring it back for January.
I would agree with that.
Yep.
Okay. All right. Commissioner Tedder gave a thumbs up earlier. Commissioner Oneron, okay, thumbs up. Commissioner Kohler, thumbs up. Okay, so we're all agreed. It'll come back in January to be voted upon. All right. Item 8 on our agenda is final call for public comment. So Dallas, if we could put the slide up. Great. If anybody in the public would like to call in and make any comments to the commission, now's the time. Please call 1-888-788-0099. When prompted, enter the meeting ID 868-6086-1062. When we're ready to hear public comment, we'll call on you to speak based on the last 3 digits of your phone number. Each speaker must state their name and address for the record and will be allowed 5 minutes to speak. Please remember to mute the live stream when you are called upon to speak. To do this, we need 5 minutes. We'll be back at 9:16.
Chair, we are approaching the 5-minute mark, and I am not seeing any callers in the chat right now.
Okay, thank you, Dallas. We'll give it just a little bit more time. Okay, so Dallas, if we can get caught up with the live stream and just let us know.
And you are good.
Okay, so nobody called in, so seeing no one, we will close the public invited to be heard and go to item 9 on our agenda, which is items from the commission. As always, thank you to Jane and to Dallas and to Susan, who have been doing all of the work behind the scenes, helping us with all the technicalities. Can't do it without y'all, so thank you very much. Commissioner Onaran.
Well, lately I'm getting a lot of interest about my professional planning and architecture work in Longmont. And because of that, I decided to resign. This is my last meeting. I realized that I can be much more productive and helpful in Longmont's development as a professional service provider. So I really enjoyed my experience with you and enjoyed discussing with every one of you. And hopefully in the near future, you're going to see me as applicant's representative and will come in front of you. Thank you.
Well, thank you, Corkett. Really, it's been a pleasure serving with you and having you on the commission, and always have made me think quite a bit about what's been in front of us. So really appreciate it. You actually have given me a great segue to what I was going to mention, which is we have some changes to the commission. So Michael Pollan, I believe, if I understand right, you have been reappointed for another term as a regular member. Congratulations.
I appreciate it. Thank you.
Yep. I too have decided to end my service as of this is my last meeting. So it's been 11 years for me serving on this commission as an alternate and regular member. So I'm ending 1 year early. I was going to be term limited at the end of next year, but Commissioner Lukács, who's been an alternate for us, she's been appointed as a regular member. She will fill the 1 year remaining on my term. We have a new alternate to fill Commissioner Lukács's alternate position, and that is someone named Amy Saunders, who I believe has prior boards and commissions experience with the city. And so, yeah, this has been a great experience for me. And really, it's just been a fabulous way to give to our town. And I look around the city and I see projects that we've been involved with, and I think back on the discussions and what's changed, and I'm really proud to say that I can see good positive changes to Longmont. So thank you all. Commissioner Pollan.
Yeah, I just want to say it's been an honor both serving with Commissioner Onaran and also with you, Chairman Shernick. So wish you two both the best of luck and appreciate all the work that you have done.
Thank you very much. Appreciate that. All right. Oh, Commissioner Flake.
Yeah, people say it all the time, you will be missed, but you will, both of you, be missed, because I look forward to the comments that are made, and I think they contribute to our discussions and our decisions. And I think, Chair, you have run the meetings exceedingly well, and for that I'm very grateful.
Well, thank you very much. Sometimes I've bobbled a few things, and the memory doesn't always work quite right either. So, but thank you. Any items from our council representative, Aaron Rodriguez?
Well, this was a bit unexpected for me, but thank you so much to Commissioner Onaran for your service, and as well as to Chair Schumick. it's been, definitely a pleasure serving with you this entire time. And I wish you the best of luck in the future, and happy holidays to all the commissioners and the staff that are still on the call. Thank you.
Thank you very much. Items from our planning director, Glenn Van Nimwegen.
Well, I just echo the same feelings. I met Michael when I first walked in the door, so you've helped me out quite a bit. And Corcut as well. I think both of you brought a little bit more depth to all the discussions, so you will be missed. And I'd like to thank all the planning commissioners. This was a tough one tonight. Everybody gave it their all, and I really appreciate that. So yeah, enjoy your holidays. And it'll be a new year when we're back.
All right. Thank you, Glenn. Happy New Year to everyone. Take care.
Michael Corcutt, good luck. Thank you.
Thanks.
Bye-bye.
Happy New Year.
Thank you.
You too.